Welcome to our Regulations video series. I'm Laura, your Customer Success Manager, here to guide you through the Pennsylvania Wiretapping and Electronic Surveillance Control Act, WESCA, and its key compliance requirements for businesses operating online. The Wiretapping and Electronic Surveillance Control Act is Pennsylvania's wiretapping law enacted in 1978. It prohibits intercepting any wire, electronic, or oral communication unless all parties consent first. In 2022, a federal appeals court held that this law can apply to website tracking technologies, opening the door to a wave of class actions over session replay tools, chat features, and tracking pixels. WESCA was enacted on October 4, 1978, and amended in 1988 to cover electronic communications. In 2012, the legislature narrowed the direct recipient exception so it applies only to law enforcement. That change proved decisive in August 2022 when the Third Circuit held in Popa Harriet Carter gifts that WESCA applies to website tracking, triggering a wave of class actions. Pennsylvania Wiretapping and Electronic Surveillance Control Act applies to any business that intercepts or records communications involving people in Pennsylvania. Because courts treat the interception as occurring at the visitor's browser, out-of-state companies can be sued in Pennsylvania over their website's tracking. It covers websites using session replay, chat tools, and pixels, call recording, and the third-party vendors who receive visitor data. The key exemption is all-party consent, which may in some cases be implied through clear disclosures, though a buried privacy policy link alone may not be enough. Since 2012, the direct recipient exception applies only to law enforcement, so ordinary businesses and their vendors cannot rely on it. Service providers acting in the ordinary course of business are also covered by an exception. Businesses must obtain consent from all parties before intercepting or recording any communication. Inventory. Every technology that captures visitor or customer communications, remember that being a party to the conversation is not a defense under WESCA. Announce call and chat recording before it begins, and keep records showing when and how each consent was obtained. Website owners should obtain prior affirmative consent before session replay, pixels, or similar tools start running for Pennsylvania visitors. Disclose clearly that interactions are recorded and shared with third parties. Courts expect disclosures that would actually alert a reasonable person. Show a recording notice before chat sessions, block third-party scripts until consent is given, prefer click-through consent over passive disclosures, and keep time-stamped consent records. Remember that jurisdiction follows the visitor. Companies with no presence in Pennsylvania can still face WESCA claims. Litigation turns on whether a tool captures the contents of communications, whether it is a device under the law, and whether valid consent existed. Review your vendor contracts and keep in mind that with no comprehensive state privacy law, WESCA is the primary vehicle for online privacy claims in Pennsylvania. Individuals have the right not to have their communications intercepted, disclosed, or used without consent. They can sue directly and recover liquidated damages of $100 per day of violation, or $1,000, whichever is higher, plus punitive damages and attorney fees. Unlawfully intercepted communications are also generally inadmissible in court. Unlawful interception is a third-degree felony in Pennsylvania, punishable by up to 7 years in prison and a $15,000 fine. On the civil side, plaintiffs can recover $100 per day or $1,000 per violation, whichever is higher, plus punitive damages and attorney fees. Since the Popa decision in 2022, class actions over website tracking have surged. Thank you for joining us. At Clym, we're here to help you navigate compliance with ease. Visit us at clym.io to learn more about our all-in-one digital compliance solution.